we are concerned with the problem as to how the legal system allocates ownership rights in the family home. In this module, we'll look at the purchase price resulting trust, one type of presumed resulting trust, as a way of dealing with this problem. We'll see that this is a straightforward approach that allocates ownership rights in proportion to the financial contributions that each of the parties made to the purchase price. Simplicity and certainty are attractive characteristics. Any disputes about ownership rights are resolved according to clear and predictable principles. This means less litigation, and that any litigation there is should be relatively simple and so less expensive and time-consuming. The purchase price resulting trust is certainly one tool in Hong Kong's legal system for dealing with ownership disputes. One way forward for the law of the ownership of the family home would be to concentrate on developing and refining the existing law of the purchase price resulting trust. In this module, I make some suggestions about possible improvements. I suggest, though, that the purchase price resulting trust cannot be the legal system's only tool for dealing with ownership rights in the family home. First, it clearly should not operate where there's evidence that the parties did not intend their ownership rights to reflect financial contributions. Second, it can be argued that the purchase price resulting trust is unfair to parties who contributed to the well-being of the family in non-financial ways. It can be unfair, for example, to the person who concentrated on looking after children and maintaining the home. The law of trusts starts with the presumption that the answer to the question, who owns the family home, is to be found in the title deeds. It's for the person trying to establish the existence of a trust to prove it. Suppose, though, that the legal title to the family home is in the name of just one of the couple A, but the other person, B, has contributed to the purchase price. Equity presumes that B has an equitable interest in the property in proportion to the contribution to the purchase price. If B has contributed 40% of the purchase price, then B has a 40% equitable interest in the property. A is holding the property on trust as to 60% for A and as to 40% for B. Another example is where the title deeds say that A and B own the property as joint tenants, but A has contributed 60% of the purchase price and B has contributed 40% of the purchase price. Under the purchase price resulting trust, A and B as legal joint tenants hold the property on trust for themselves as tenants in common, with their shares corresponding to their contributions to the purchase price. The purchase price resulting trust is brought into existence when someone other than the legal owner contributes to the purchase price. But what is the purchase price? The purchase price resulting trust in Hong Kong is based on payments made at the time of acquisition of the property. Payments that are made later or payments made to improve the property in some way are not considered. This is an unnecessarily rigid and unhelpful approach. The most obvious criticism is that most people rely heavily on mortgage finance to pay for the property. The purchaser might only pay a small proportion of the purchase price from his or her own resources. The rest of the purchase price is supplied by a lender and is secured by a charge over the property. Being a party to the mortgage, and so accepting an obligation to make the payments due under it, is seen as a way of contributing to the purchase price. If A and B each sign a mortgage to secure 90% of the purchase price, they are usually regarded as having jointly contributed 90% of the purchase price. What, though, of the person who is not a party to the mortgage, but who does contribute to the payments due under it? Suppose that title is in A's sole name, but B makes some of the mortgage payments. Since title is in A's name, it's unlikely that B will be a party to the mortgage. B's payments are not seen as a contribution to the purchase price, and they do not give rise to a trust in B's favour. To extend this point slightly, What if B in the above example does not make mortgage payments, but pays all the other household bills, pays for food, electricity, school fees, and so on? Again, these payments do not give rise to a trust in B's favour, since they are not contributions to the purchase price. This may be unduly rigid. B is making a vital financial contribution to the household budget, and yet B is not rewarded with a share in the family home. This is the problem of the treatment of indirect financial contributions. One of the most significant criticisms of the purchase price resulting trust when applied to the ownership of the family home is that it does not give any credit for domestic contributions. Suppose that A is the breadwinner who supplies the purchase price and that A is the only party to the mortgage. B is the homemaker who makes no financial contributions but who concentrates on looking after the home and taking care of the children. The purchase price resulting trust does not give any credit to B for these domestic contributions. It may be, however, that A could not have concentrated on being the breadwinner unless either B had been prepared to take on the homemaker role or A paid someone else to do the work of the homemaker. Similarly, it may be that B took on the homemaker role in reliance on an express or implicit understanding that each was contributing to a joint venture and that each had an ownership interest in the family home as a result. It may be that B would not have been prepared to take on the homemaker role, perhaps giving up the opportunity to be a breadwinner, without an understanding that B had an ownership interest in the family home. It's unrealistic to expect B to insist on a contract to record this understanding. B may well regard this understanding as being a central part of what it means to be married or of the relationship with A. The purchase price resulting trust is based on equity's presumption that when B contributes to the purchase price of the family home, B does not intend to make a gift to A, but intends to acquire an ownership interest in the family home. Where, however, B is A's husband, B is rebuttably presumed to intend to make a gift to A of any money that B gives to A. This presumption of an intention to make a gift is the presumption of advancement. It has been said that it's a weak, easily rebutted presumption. There's no presumption of advancement where B is A's wife and B gives money to A. There's no presumption of advancement as between unmarried cohabitees. The presumptions of resulting trust and of advancement are based on the court's experience, and we can expect that they will be updated by the courts to reflect changes in society and social attitudes. For example, there's a presumption that fathers intend to make gifts to children, but it was long thought that mothers did not. We've just seen that there's a presumption that husbands intend to make gifts to wives, but not the other way round. This difference in the way that equity treated wives and mothers arose in times when women were often financially dependent on their husbands. Nowadays, this is often not the case. There has been some updating of the presumptions to reflect this change in women's financial status. It's now presumed that mothers also intend to make gifts to their children. The presumption of advancement as between husbands and wives is only a weak presumption. Still, given the right opportunities to do so, it might be helpful for the courts to consider the role of the presumption of advancement in modern times. Would it be appropriate to decide that there's no presumption that husbands intend to make gifts to wives? More radically, might it be appropriate to consider a presumption that in certain circumstances both parties in a relationship intend to make gifts to themselves as joint tenants? In fact, Stack and Dowden has given rise to this presumption in certain circumstances. After Stack and Dowden, where title to the family home is held in joint names, there is a presumption of an equitable joint tenancy. This is presented as an aspect of the law of the constructive trust, but it could be rethought as an element of an updated purchase price resulting trust. The purchase price resulting trust is one type of presumed resulting trust. B's contributions to the purchase price of a property legally owned by A give rise to a presumption of a trust in B's favour. The presumption of a trust is rebuttable by evidence of some contrary intention. It arises only where there is no admissible evidence of some other intention. One thing to be considered here is what other evidence of a contrary intention ought to be given weight. This is one of the major themes of Lord Newburger's speech in Stack and Dowden. Clearly, a formal express agreement should be decisive and should mean that there's no room for the purchase price resulting trust. Perhaps the same should be true of informal express agreements. Arguably, that should be the end of the matter. Perhaps the law should be that the purchase price resulting trust should apply unless there's some properly evidenced express agreement to displace it. Otherwise, the law should simply give effect to the ownership position in the legal title. This would be clear and certain. Would it be just? Perhaps this introduction has given you some ideas for a possible research topic. Do you think, for example, that there's an argument for trying to give the purchase price resulting trust a much bigger place in the law of the ownership of the family home than it currently has? Would it need to be modified or developed in any way? For example, what payments or other contributions should count as a payment for the purchase price resulting trust? How should the purchase price resulting trust interact with other relevant doctrines or legislative codes? The guide for this module includes some readings that might help you carry out research in this area.